Welcome to the first annual UC Irvine School of Law Supreme Court Term in Review event. I'm Professor Rick Hasen of UCI Law, and I'm so pleased that so many of you could join us here in person for this event, and many more of you watching over the live webcast. Each year, the Supreme Court decides fewer than 100 cases. Those cases can have major effects on areas of public policy ranging from criminal law to the environment, to sexual freedom, to immigration, to the law of politics. The Court just completed its 2010 term, deciding 82 cases. Perhaps this was the wrong year to start our first annual Supreme Court Term in Review event. Panelist Dahlia Lithwick commented on the low-carb finish to a quiet term. Former Solicitor General Greg Baird called the term, which just ended, the calm after the storm of Citizens United and before the storm of healthcare. Also waiting in the wings for possible Supreme Court review are cases involving the constitutionality of a ban on same-sex marriage, as well as Arizona's controversial immigration law. So this means that the second annual Supreme Court term review event is even more exciting than this one. Yet even this quiet term had its share of important cases, which concerned issues including the scope of class actions and access to the courts, the First Amendment and the ability to regulate violent video games and to regulate the campaign financing of elections, important questions of federalism, the release of prisoners to solve severe overcrowding and health problems in California prisons. So even in a slow term, the Court's rulings can have monumental effects on people's lives. With us to sort out all of the issues is an all-star panel of Supreme Court experts. In alphabetical order, they are Erwin Chemerinsky. He's the founding dean and distinguished professor at the University of California Irvine School of Law with a joint appointment in political science. Previously, he taught at Duke Law School for 4 years, during which he won the Duke University Scholar Teacher of the Year Award in 2006. Before that, he taught for 21 years at the University of Southern California School of Law and served 4 years as director of the Center for Communications Law and Policy. Chemerinsky also taught at the UCLA School of Law and at the DePaul University College of Law. His areas of expertise are constitutional law, federal practice, civil rights and civil liberties, and appellate litigation. He's the author of 7 books, most recently The Conservative Assault on the Constitution. Dr. John Eastman is the Henry Salvatore Professor of Law and Community Service at Chapman University School of Law, and also served as the school's dean from June 2007 to January 2010, when he stepped down to pursue a bid for California Attorney General. He's the founding director of the Center for Constitutional Jurisprudence, a public interest firm affiliated with the Claremont Institute. Previously, Dr. Eastman was the Henry Salvatore Professor of Law and Community Service. Prior to joining Chapman's faculty in August 1999, he served as a law clerk for Justice Clarence Thomas at the Supreme Court, and with Judge J. Michael Ludden of the United States Court of Appeals for the Fourth Circuit. Laurie Levenson is Professor of Law and William M. Raines Fellow and David Bertram Chair in Ethical Advocacy. While in law school, Laurie Levenson was Chief Article Editor of the UCI Law Review. After graduation, she served as law clerk to the Honorable James Hunter III of the United States Court of Appeals for the Third Circuit. In 1981, she was appointed Assistant United States Attorney Criminal Section in Los Angeles, where she was a trial and appellate lawyer for 8 years and attained the position of Senior Trial Attorney and Assistant Division Chief. Levenson was a member of the adjunct faculty of the Southwestern University School of Law from 1982 to 1989. She joined the Loyola faculty in 1989 and served as well as Associate Dean for Academic Affairs from 1996 to 1999. Laurie is a nationally recognized expert on issues involving criminal law and criminal procedure. Dahlia Lithwick is Senior Editor at Slate, and in that capacity, she writes the Supreme Court Dispatches and jurisprudence columns. Her work has appeared in the New York Times, Harper's, the Washington Post, and Commentary, among other places. She received the Online News Association's Award for Online Commentary in 2001 and again in 2005, and for a series she co-authored on torture, and was the first online journalist invited to serve on the steering committee for the Reporters Committee for Freedom of the Press. She's co-author of Me Versus Everybody, Absurd Contracts for an Absurd World, a legal humor book, and I Will Sing Life, Voices from the Hole in the Wall Gang Camp, a book about 7 children from Paul and Winnie's camp with life-threatening illnesses. She lives in Charlottesville, Virginia with her husband and 2 sons. And finally, David Savage, Supreme Court correspondent from the Los Angeles Times. He has served in that role since 1986. Working out of the paper's Washington, D.C. Bureau, Savage has had an excellent vantage point from which to observe the High Court's actions, decisions, and changes over 3 decades. Prior to taking up the court fee, Savage was the Times education writer based in Los Angeles. Savage is the author of Turning Right, The Making of the Renter's Court, published in 1992. He also writes a monthly column for the court for the ABA Journal and offers regular legal commentary on National Public Radio's Talk of the Nation program. Savage, who for good or ill is not a lawyer, grew up in the Pittsburgh area and holds degrees from the University of North Carolina at Chapel Hill and Northwestern University. The format for today is as follows. I'll give each panelist about 7 minutes to talk about 2 topics: the theme of the term, or their overall impressions of the term, and to highlight at least one important case from this court's past term. After the first round, we'll have about 15 minutes of back and forth among the panelists. They can reflect on what others have said. And then we will open it up to the audience for questions. That will leave us about a half an hour for questions. And if you are a UCI Law student out of town watching this, we invite you to submit your questions by Twitter. If you have a question, please tweet it using the hashtag UCI Law SCOTUS. If you have no idea what I just meant by that, you can send an email to our@law.uci.edu. And with that, I'll turn it over to Erwin Chemerinsky, and we'll go in alphabetical order. So we'll hear from Dean Chemerinsky, John Eastman, Laurie Levenson, Dahlia, Lithwick, and David Chapman.
Thank you. Let me take a moment in my role as Dean to welcome all of you here. I want to start by thanking Rick Hasen for conceiving of this program and putting it together. I hope it truly will be the first of many years of such programs to come. And I want to thank the panelists for taking time from the busy schedules to come to UCI. Especially I want to thank David and Dahlia for making the trip from Washington, D.C. Laurie and John. Laurie was in D.C. just yesterday, but Laurie and John making the shorter trip here from within Southern California. I want to thank Brittany Rodriguez, our wonderful events coordinator, who's responsible for all the logistics that go into this. And most of all of you for being here. We had 190 people sign up to be here today. For the first time we're doing the program, it's just astounding. I think that the central theme of the term that completed a couple of weeks ago is the Supreme Court closing the courthouse doors. To me, there were a stunning number of decisions this term which were about restricting access to the courts. I want to talk about a few of them in my few minutes, but I know that other panelists will be alluding to many of these other decisions as they go along. Let me start with AT&T versus Concepcion. The Concepcions bought cell phones from AT&T. Like all of us, they were asked to sign an agreement in connection with their cell phones. And my guess is, like all of us, they didn't read the agreement that they signed. Had they done so, they would have seen that there was a clause within it that said that if there were any disputes with AT&T, they would agree that they would go to arbitration. AT&T had advertised that there were free cell phones. They actually charged the Concepcions $30.22 in sales tax. The Concepcions then joined with a class action suit in federal court for fraud against AT&T. AT&T had offered free phones, was charging the consumers money. AT&T moved that the Concepcions not be able to be part of litigation, but instead have to go to arbitration as their consumer agreement provided for. However, the California Supreme Court, in the Discovered Bank case, said that arbitration clauses in such consumer contracts are not enforceable. The Federal Arbitration Act is a law that was adopted in 1925. It says that contracts in interstate commerce that have arbitration clauses shall be enforced, except that those clauses are revocable under state law. The California Supreme Court had said, since there's no bargain for exchange with regard to such clauses, and since they're against public policy of facilitating class actions, they're not enforceable under state law. Both the Federal District Court and the Ninth Circuit ruled in favor of the Concepcions based on this clause in the Federal Arbitration Act and based on the California Supreme Court ruling in Discovered Bank. The Supreme Court, in a 5-4 decision, reversed the Ninth Circuit. Justice Scalia wrote for the court, joined by Chief Justice Roberts, Justice Kennedy, Thomas, and Alito. Justice Scalia said that the Federal Arbitration Act evidences a strong policy in favor of arbitration. He talked about the tremendous virtues of arbitration with regard to efficiency. He said these virtues would be lost even if it were class arbitration. He said the procedural simplicity, the lack of litigation of procedural issues would all be compromised even in class arbitration. He talked about, and here I quote his words, the interim effect of class action suits on corporations, forcing them to settle even non-meritorious claims. Justice Breyer wrote a strong dissent joined by the other justices. Justice Breyer said the alternative here isn't millions of other claims against AT&T. He said realistically it's no claims against AT&T in arbitration or in litigation. He said the world we live in is people aren't going to sue for $30.22 or even go to arbitration for $30.22. The whole point of class actions is to facilitate a large number of people being able to go forward, but they each lose a small amount of money. The corporations here are tremendously enriched by knowing that they're not going to be liable through the class mechanism. And Justice Breyer concluded by saying, what about federalism in deference to the states? After all, California Supreme Court had specifically said under state law, this is a contractual provision that's not enforceable. And if the court's going to be serious about deference to the states, in light of the language of the FAA, how can this clause be enforced? As I alluded to in my introduction, this is not the only case this term that involved closing the courthouse doors. Let me just mention a few others. There was the case that got a great deal of media publicity, Walmart versus Dukes. This was a class action by as many as 1.6 million women employees of Walmart claiming sex discrimination with regard to pay and promotions. The question is, could it go forward as a class action? Here, in a 5-4 ruling, the Supreme Court said there wasn't sufficient commonality to allow it to go forward as a class action. The Supreme Court, with Justice Scalia writing, joined by the same justice, said that Walmart has an official policy prohibiting sex discrimination. So the decisions with regard to pay and promotion were made by store managers and assistant managers all over the country. And the court rejected the evidence that it had presented that suggested that there was an underlying policy that led to all of these different decisions across the country. It's going to be very difficult to have employment discrimination class actions after Walmart versus Dukes. So it's a small workplace. We have one decision maker or two decision makers. There's not likely to be enough people employed to have the numerosity that's required for class action. But you have a large workplace, even a university like this, where employment decisions are made in so many different departments and schools by so many different people, then the Supreme Court says inherently there's not the commonality for a class action suit. Both of these cases tremendously protect business at the expense of consumers, employees. Let me mention one more case in my remaining time. A decision called Pleva versus Mensing. 2 years ago, in Wyatt versus Levine, the Supreme Court said that drug companies can be sued for failure to adequately warn patients and doctors, even if they're in compliance with FDA prescribed warnings for their drugs. Pleva versus Mensing held, however, that makers of non-generic drugs cannot be sued for failing to adequately warn patients and doctors. Justice Thomas wrote, again it was 5-4, again the conservative justices were the 5 in the majority. And he said that claims against generic drug makers are preempted, even when the claims against non-generic drug makers are not preempted. He relied on the language of a statute that seemed to be saying that generic drugs should have the same warnings as non-generic drugs, a statutory provision that had Waxman amendments that were meant to protect consumers. But the bottom line after this case is individuals who are injured by non-generic drugs can't sue the drug company, even if the maker of the non-generic drug would be able to be sued in the same circumstance. 75% of all prescriptions in the United States are filled with generic drugs. That rises to 90% where there's a generic equivalent or a non-generic. And all of these people are shut out of any recovery in any court. Now, I've mentioned just 3 examples of courts closing the courthouse doors. I think you'll hear of others. To me, that really is the central theme of the court. We take so seriously in this country the notion that any person with a claim should have his or her day in court, but the majority of the Supreme Court doesn't seem to believe it.
Thank you.
Okay, whoops, sorry. All right, so this month marks the 11th year of Erwin and I doing a weekly debate on a national radio show. I think during the course of that 11 years, we've agreed 4 times. And I'm going to start, and one of them was that the host does a good job moderating my debate. I went out of my way to try and find one case in the term where we might agree. And I think I found it. And it's along, actually, his central theme of closing the courthouse doors, although I disagree with every one of the examples he gave. But I want to take up a case where I agreed. And this is a project that's been ongoing by Justice Scalia for a long time. And it's one of the few areas in which I disagree with Justice Scalia. And now, my former boss, Justice Thomas, who joined with Justice Scalia in the opinion I'm going to talk about. The case is Arizona Christian School Tuition Organization versus WIM. It's a 5-4 decision written by Justice Kennedy. And the issue there was whether taxpayers have standing to challenge a state tax credit mechanism that was used for people to donate to charities if the money that the charities then used to support religious as well as non-religious schools. The claim that the support for the religious school out of this tax credit scheme amounted to a government sponsorship or an establishment of religion. The court decided the case on standing grounds, 5-4. Justice Kennedy said a tax credit is not the same thing as an expenditure by government, and therefore the narrow exception to taxpayer standing that we've allowed in Establishment Clause cases, where your tax revenues are being used to support, allegedly, an establishment of religion in violation of the First Amendment, that narrow exception didn't apply because your tax revenues were not being used. You were just offended that somebody else was getting a tax credit and then being able to use their own money in ways that you didn't like. And so Justice Kennedy said that the distinction between those two, the credit versus an expenditure, matters greatly for the exemption. Justice Scalia wrote separately. And in an ongoing effort, and there was a lot of speculation that he might have actually gotten to the point where he could get 5 votes for his position here. We have this dichotomy in our taxpayer standing jurisprudence. Normally, taxpayers don't have standing to challenge any federal spending program on the ground that they don't suffer a particularized harm different from any other taxpayer. And that the narrow exception for Establishment Clause cases that allows that creates this disconnect. If you're challenging it on Establishment Clause grounds, you can have taxpayer standing, but any other provision of the Constitution being exceeded, whether it's the General Welfare Clause or the Common Defense Clause or the 27th Amendment that has a specific restriction on congressional spending for their own pay, you don't have taxpayer standing. And Justice Scalia has long said that that dichotomy makes no sense. Now here's where I disagree with him. He wants to get rid of the exception. I would get rid of the rule. Because I think it's fundamentally important to have taxpayer standing, in fact citizen standing, to insist that the government comply with the terms of its charter. It's our contract with the government, that Constitution. And when they exceed their authority, every one of us is harmed, not with a particularized injury, but the Constitution doesn't limit our challenges in court to particularized injuries. Article 3 very specifically says that we have law and equity jurisdiction in the federal courts. Particularized injury was a component of the law jurisdiction. It was never a requirement or a component of the equity jurisdiction. In fact, many individuals harmed by small amounts was a vintage type of equity claim in the old equity courts. And so I think Justice Scalia is just wrong on this. And I'll come back to that in a moment, because underlying his philosophy, oddly, in this case, is something that I think infects the dissenting opinion as well. And the dissenting opinion is by Justice Kagan. And I want to give a little added kind of inside baseball aspect to this case as well. And that is the disagreement between Justice Kagan, former Solicitor General of the United States, and her chief deputy and successor as acting Solicitor General, Neil Katyal, whose briefs in the case took the position that Justice Kennedy adopted at great odds with Justice Kagan's position here. And so you've got this very odd thing that Neil Katyal was doing as a Solicitor General. It raised quite few hackles among the Supreme Court bar, particularly the professoriate around the country. What is Katyal doing? Anyway, Justice Kagan in her dissent, and I use this to kind of go to the underlying philosophies, and I think we'll see here a precursor of some of the coming fights, and then I'll close with talking about what I think is the theme of the term, and that is precursor for the coming fights, and you see lots of skirmishing going on. So Justice Kagan's dissent says this credit has cost the state of Arizona $350 million. And by giving this tax credit, they are targeting that money to go to religious institutions, creating an establishment of religion. This subsidizes religion, she says. Either way, the government has financed the religious activity, and therefore the taxpayers ought to be able to bring the suit, she says. She equates tax expenditures, which is the kind of standard terminology for if I give somebody a tax credit, which means I don't take their money, that I'm making a government expenditure for the purpose of the tax credit. And so she would allow the taxpayer standing. Now, it seems to me that if you kind of dig down into the underlying philosophy of her opinion, there's an amazing amount of agreement with Justice Scalia's opinion. The notion that a tax credit amounts to government spending presumes that the government basically has access to all the resources. And if I don't take your money, I'm making a decision to spend that for something else. That's a tax expenditure. And if I do take the money, then I just spend it more directly. But I'm still doing the same thing with the kind of government pool. A very interesting notion on the role of government and its omnipresence in our society. Well, it seems to me that Justice Scalia's position is exactly the same. Not on the spending front, but on the notion that no taxpayer, no citizen has the authority to challenge government unless they have a particularized injury. We've converted the government from one of limited power to an omnipotent one that has all the powers except those that are specifically prohibited to it when an individual right is infringed. And that's the kind of reading of the Bill of Rights that is exactly opposite to what James Madison and the other founders thought it was. It assumes an all-powerful government within certain carve-outs, but beyond that, nothing else. And so there's an interesting philosophical mix. So I said the theme is the kind of precursor. As Rick pointed out, healthcare and immigration on the pike. And I'll just mention two quick cases and I'll be done. There are a couple of cases, obviously Chamber of Commerce versus Whiting, dealing with Arizona's immigration statute, a preemption case, but there's a lot of implication in that case, reading between the lines for the SB 1070 challenge that is going up there next term. And then a couple of other cases. One, a sleeper unanimous decision, Bond versus United States. And just a minute on the facts of that case. Mrs. Bond was elated to discover that her girlfriend, her best friend, was going to have a baby, until she discovered that the best friend's baby was fathered by her own husband. Kind of turned elation to a different kind of view of the thing. She worked at a chemical lab, stole some chemicals, and started trying to cause chemical burns on her former best friend. Instead of being charged with assault, as this clearly was under state law, she was charged with violating the International Chemical Weapons Ban Treaty. And the Third Circuit Court of Appeals, when she raised a challenge to the constitutionality of this prosecution in the statute, said that she didn't even have the standing to challenge the constitutionality of the statute under which she was being prosecuted. The Ninth Circuit unanimously ruled otherwise on a confession of error by the United States government itself, which is another side story as well. But significantly, and again for my theme of this court, the kind of skirmishing of going forward on the health care bill, Justice Kennedy writes the opinion. Now a lot of people think Justice Kennedy will be the deciding vote on the health care suit when it gets up there. That opinion is full of the recognition of the state's rights, the police power, the powers not given to the federal government, the notion that that distinction between federal and state governments protects individual rights, and therefore, of course, she has standing, is a very strong statement of kind of laying some markers down for the health care bill, in my view. Now, he gets joined by a lot of people that are definitely not voting to overturn the health care law, so you don't want to read too much into that. But for Justice Kennedy writing such an opinion at such a time, I think it's significant.
Thanks very much, John. We'll turn to Laurie Levenson.
First, let me thank Erwin and Rick so much for inviting me to be on this panel. I'm delighted to be here, and I think my theme is so much law, so little time. I'm going to give you the themes in the various areas of the criminal laws and as you know, there are many different areas. I thought I would start with one of the most important cases of this term. That would be Davis versus United States, a Fourth Amendment case. So what would be the theme of the Fourth Amendment? The not-so-slow death of the exclusionary rule. I think what we can see in Davis is a pattern, and it lays it out boldly in the case itself, that the court has been moving away from the exclusionary rule, at least as many of us learned it in law school. This was a 7-2 decision written by Justice Alito. He wrote a couple of the Fourth Amendment decisions this term, and here are some basic facts so you can understand it. What happened, there were some police officers stopped someone for an arrest in a car. They did a search incident to the arrest of the passenger compartment in the car, which would have been fine at the time of that arrest, because we had a case called Belton that said, and most people interpret it as allowing. But the Supreme Court just last term said, no, that's not what we meant in Belton. And in a case called Gant, they said, if the passenger is in the back of the patrol car of the driver and can't get access to the car, then you can only search for evidence of the crime of arrest. So what happened here is that you had police officers who at the time they did the search were acting in good faith as to how their courts had interpreted the law, but by the time the case went up to the Supreme Court, the law has changed. And the Supreme Court had to decide a couple of issues. One is, would they see this as a retroactivity issue? And they didn't change the standard on that. But then they said, you know what? The exclusionary rule should not be about punishing officers who are trying to do the right thing. And that would be the theme of the good faith exception. Now, the good faith exception came in 1984, 25 years ago at least. And at the time, there were a lot of defense lawyers who are saying, this is scary. Because once you move away from the set warrant requirement and set exceptions, where's it going to go? Well, now we know where it went. We had a good faith exception where you had a technically bad warrant. Now in a good faith exception where there was something wrong in the court files. A good faith exception when there's something wrong in the statute. And the biggie of all of these was the Herring decision that came out just a couple years ago. And in the Herring decision, the Supreme Court said, you know what, if you have officers, they have bad computer files. So they happen to have a warrant for Judge Guilford in their files that shouldn't be there. But they rely in good faith on it. At least they weren't intentionally violating his rights or acting with gross recklessness. We don't need to use the exclusionary rule. Because all of you judges out there should be doing the balance. The balance between the need to deter the officer's conduct and the huge cost of keeping from juries the true evidence in the case. And that message was, the exclusionary rule as we know it is no longer around. It's more an individual view of what the balancing is. Now, it's not gone completely. I think there are 4 justices ready to say it should be. It hangs on by Justice Kennedy, who says, look, we'll keep chipping away with these exceptions. And that's what we've done. We've created another good faith exception. Now add on to that the layer of why they're willing to do that. It's because they're reading the Fourth Amendment as being a reasonableness standard. If the officers are acting reasonably, and you see that in some other themes. Now in the remaining 2 minutes I have, I'm going to cover all the other areas of criminal law. And I would say the theme for that is a bit of a reality check as to what are officers doing and do our constitutional principles still apply. Miranda is still alive and well. In a case JDB, which was a 5-4 decision written by Justice Sotomayor, the court decided whether when you arrest a juvenile, a 13-year-old kid who's taken out of his class, He has some learning challenges. He's put into a room with a police officer, his principal. He's told, now you want to do the right thing, don't you? And they never tell him he's free to leave until after he confesses. At that point, the issue was, do we take into account that it might be different whether a 13-year-old feels free to leave as opposed to any of us after we've been to law school? Justice Sotomayor said that's part of the Miranda standard. Why do I think Miranda is faring a little better? I think that was the farewell present actually by Chief Justice Rehnquist. When he decided in Dickerson that there was this constitutional basis for Miranda, it gets respect. But the exclusionary rule, remember that judge-made rule, doesn't get that respect, and it is falling by the wayside. A couple other quick areas on the Confrontation Clause. That has been a really hot area for the Supreme Court. There were two decisions that came down, Michigan versus Bryant and the Bullcoming case. Michigan versus Bryant is probably best known for the language used between the two justices, Justice Sotomayor and Justice Scalia. Justice Sotomayor said, in terms of the Confrontation Clause, you could allow in the hearsay. This was a person who had been shot a half hour earlier. The police show up on a 911 call. He says he's asked repeatedly by 5 officers who did it. He identified Bryant, and he keeps saying, when are you going to take care of me? Well, they didn't take care of him soon enough, and he ended up dying, so his statement came in. Justice Scalia, who is the godfather of the, don't tell Mike put it that way, but, you know, the father of the Crawford Doctrine that says there's a right of confrontation, felt that this was a misuse of allowing an exception because what the police wanted to do was really sort of formalize his testimony in case he died. Justice Sotomayor read it differently, and the language they use is that Justice Scalia said about Justice Sotomayor's decision that she has, quote, an active imagination, and these are the gross distortion of facts. On Saturday Night Live, they might have introduced this differently. Shayna, you ignorant, you have it. But she holds her own, Justice Sotomayor, and it's good to see the fight back. The other case, though, is Bullcoming, which did say to prosecutors, no shortcuts. If you want to bring in lab tests that convict somebody for DUI or on DNA, you got to bring in somebody who actually had something to do with the testing. And that carried the day. Finally, I'll mention Cullen versus Pinholster, which in the death penalty and habeas corpus area is huge. And the issue comes out of a death penalty case right here from the Ninth Circuit, argued by federal public defender Sean Kennedy. The question was, when the federal courts have an evidentiary hearing and find that in fact there had been ineffective assistance of counsel, are they going to be limited by what was presented to the state courts? How much does that deference go? Well, it goes all the way. And basically they said, the one shot you get to present that evidence is the state courts. Now this might work if the state courts actually realize that and start granting hearings in death penalty and other habeas corpus proceedings. But if they don't, we may have very well eviscerated the federal evidentiary hearing for habeas corpus. The last reality check would be the Plata case, a case that has pictures, so I know my students will look at it. The pictures are of our California prison system, which was operating at 200% capacity. The court said that the 3-judge PLRA, Prison Litigation Reform Act court, that found that because of the gross overcrowding, there are 8th Amendment violations, which, because you're eating lunch, I won't repeat them. Okay, people standing in their own waste for 5 hours in cages. We have 1 inmate a week at least dying in California from the lack of health care that they should receive. The court said it wasn't beyond the scope to say that you have to reduce to 137% of capacity. So that was the big decision that you read about in the paper. A lot of scare tactics saying, oh, we're releasing 46,000 inmates. Well, actually, the state has 2 years to figure out the plan and do it. They'd already released 15,000 by the time of the decision. And practically what it means is already in California, we release about 10 inmates per institution just because it's their time for parole. This decision will make it 12. Yeah, it changes the odds that there will be a Willie Horton, but given what's going on in the courts, it probably made sense. So that would be the roundup in the criminal area.
Thank you, Laurie. And we'll turn to Dahlia Lithwick.
Well, I also want to say thank you to Dean Chemerinsky and to Rick for inviting me to this event, and I'm really looking forward to next year when the cases are super interesting. But I'm going to just briefly talk about themes, and then I'm going to talk about the First Amendment cases. You know, the one thing that I have to talk about just briefly is what it means to have 3 women at the court for the first time. It really was a big, big difference watching oral argument with 3 women on the bench this year, and it really does feel like an entirely different institution than the one that I've covered for 12 years prior to that. You know, the other theme that I think bears mentioning is that yet again this year it's Anthony Kennedy's world. We all just live in it. You know, according to SCOTUS blog, Justice Kennedy was in the majority in 80 out of the 82 merits decisions this year. That's 94% win record. He voted with the 4 conservative justices in 10 of the 16 5-4 decision. He voted with the 4 liberal justices in 4 of the 16 decisions. But lest you think anything else matters, and certainly I think going to John's point, looking forward to next year, you know, this is very, very, very much Anthony Kennedy's bench, and all those hot button cases that we talk about for next year, I think you're going to want to look to Anthony Kennedy first and foremost. My third theme, just briefly, that I'll touch on is that this really was the year of living extrajudicially, by which I mean that there was just an enormous amount of attention focused this year on the justices' behavior off the bench. And I think that that has very, very serious implications for how we think about the court, the legitimacy of the court, the current arguments about who is going to recuse themselves for the ACA case next year. I've never seen anything like that. And I think that, you know, whether it's John Paul Stevens speaking very frankly about the Thompson versus Connick decision, whether it's Sandra Day O'Connor dialing people in the middle of the night accidentally in Nevada, telling them that they should be for merit selection of judges, or even the judges who are not retired from the bench, the sitting judges. I'm not even going to mention Ginny Thomas's 7 a.m. phone call, but you know, just the amount of activity that has called into question whether these justices are impartial and whether they are partisan, I think is a really, really big theme of the term, and something that we in the media have not always handled as well as we should. So those are the themes that I want to talk about, and now I just want to briefly talk about the 2 First Amendment cases, with the caveat that this is a really interesting area, the free speech cases, because it doesn't break down on any 5-4 lines that one would expect. And that makes them very, very fascinating to try to figure out what else might be going on. I'm going to just talk briefly about the 2 cases that really were, I think, the most attention-getting cases of the year. One was Snyder versus Phelps, that's the funeral protest case, and the other is Brown versus Entertainment Merchants Association, that's the violent video games case. And I should add that both of these cases in some sense got a lot of attention because they're interesting facts, right? Kids are playing horrible video games and then they're arguably get crazy, that's interesting. And the, you know, odious Phelps family is protesting at private military funerals with horrific signs, and that's interesting. But if you sort of sweep away all the interesting facts, these both stand for the proposition that free speech is still protected in America. So they're not terribly interesting doctrinally. I want to say that what's interesting about what's happening on the speech cases at court sort of starts last term, with a split that you start to see between Justices Sam Alito and Antonin Scalia, usually quite closely aligned on things, but really starting to go at each other over questions of speech, civility, how we talk to each other, and privacy. And so I want to think just briefly before I talk about this year's cases about a conflict in Doe v. Reed. That's a Washington state ballot initiative case where essentially under Washington's open government laws, if you sign a ballot initiative, if you sign a petition saying I want this question, in this case it's an all but gay marriage law, I want this to go before a referendum, that information gets published publicly on the internet. And Doe v. Reed is a question about speech and freedom of association, and the question really is, what does it mean if my act of signing a petition in a Walmart parking lot puts me up on the internet and everybody knows who I am, and I'm subject to boycott and reprisal? It's a really interesting case because at oral argument, Justice Scalia says things in his chest-thumpy way like, look, civic courage. You know, if you're going to sign a ballot petition, if you're going to legislate, stand up there and say it. People didn't even have a right to vote by private ballot. In this country, if you believe in something, you take your lumps. You say it and you take your lumps. Justice Alito and Justice Thomas in that case, very, very concerned about the implications of putting your name on the internet, and then people Google you, and then they Google map you, and then they figure out where your kids go to school. And quite literally, Clarence Thomas says, in his opinion in Doe v. Reed, the internet makes everything different. It just makes everything different. Speech isn't speech anymore because people can come to get you. And we see that play out in the other case that's interesting last year, where the court decides per curiam that they're not going to allow broadcast of the California gay marriage case. And again, the same thinking really plays out where the court says allowing televisions, or in this case YouTube video, into the court is different because people will find you and they will hurt you, and it's just, this is a whole new world we live in. So now I just want to talk about Snyder versus Phelps, but I want to open by saying briefly that before Snyder versus Phelps, Justice Stephen Breyer, promoting his book, tells George Stephanopoulos on the news that the Quran burner, the crazy Quran burner in Texas, in Florida? Florida, apologies, that he really changes everything. And that maybe we really need to reassess Oliver Wendell Holmes' notion of fire in a crowded theater. Maybe, says Justice Breyer, the internet and technology and cable news turns the whole world into a theater. And maybe it's time to really think about what it means to look at new technology and speech and to rejigger the laws to comport with that. So that's where Stephen Breyer is. Snyder v. Phelps is an easy case, right? We've got the Phelps family, despicable, going to funerals, holding up horrible signs. This is a private military funeral. This boy is killed in combat. And the Phelps family, because they believe there's some connection between America's tolerance of homosexuality and dead soldiers and God, tend to hold up signs that say things like God hates fags and thank God for dead soldiers. The interesting part of the case that falls out of the case somehow is the epic poem that the Phelps family puts up on the internet, where they say all of these things, except quite specifically, they target the family, the Phelps family in question. Snyder family wins $5 million under their claim of intentional infliction of emotional distress. The Fourth Circuit reverses, saying this is protected free speech, raising the question, why does the Supreme Court take the case? Supreme Court takes the case for reasons that are unknown, except that they're interesting facts. And then 8-1, they agree with the Fourth Circuit. This is, in fact, protected free speech. It's despicable speech. It's hateful, loathsome speech. But, writes Chief Justice Roberts, speech on public issues occupies the highest rung in the hierarchy of First Amendment values. The interesting part of the case is the one dissenter, that Samuel Alito, who writes a dissent that everyone in America seems to think is right. He says this isn't speech, this is assault, this shouldn't be protected, this is a private family, there is clearly harm, and I don't understand what the court is thinking. That brings us to Brown versus Entertainment Merchant Association. This is the California ban on violent video games, $1,000 fine if you sell a violent video game to a minor. The court 7-2 says no, the ban is unconstitutional, it violates free speech. Justice Scalia, writing for the court, says, quote, this country has no tradition of specially restricting children's access to depictions of violence. California's claim that, quote, interactive video games represent special problems is unpersuasive. And Scalia very strongly sort of compares violent video games to Dante's Inferno. He explicitly compares Mortal Kombat to Dante's Inferno, and more or less says, you know, speech is speech. You might not like the way it's happening, in this case, these interactive videos, but this is no different from you know, what all the gruesome stuff that kids read in comic books. And there's just no good evidence, he says, that it makes children crazy. Interesting part of the case, and here's where I want to conclude, is that the two dissenters are arguably the most liberal and conservative justices on the court. Clarence Thomas dissents from the decision, writing a slightly incomprehensible but certainly very passionate discussion on colonial parenting and how it was awesome back when kids were scared of their parents all the time. And here's where I remember that we are in fact podcasting. Hello. And Justice Breyer writing, and I just want to loop it back to Breyer talking about fire in a crowded theater. Justice Breyer writing a really impassioned dissent about civility and education. I just want to read this to you because this is how Breyer is thinking about the First Amendment. Quote, "This case is ultimately less about censorship than it is about education. Our Constitution cannot succeed in securing the liberties we seek to protect unless we can raise future generations committed cooperatively to making our system of government work." So you're wondering what that has to do with Mortal Kombat. I think in Breyer's view, and this is what I want to really emphasize, the breakdown in the First Amendment, the blocks and the way the two blocks are thinking about the First Amendment seems to have much less to do with free speech and much more to do with the advent of technology, with questions about privacy, right? Those questions I was talking about with reference to Doe v. Reed, that people can find you now in a way that they couldn't. Questions of civility and how people talk to each other in society, and questions of what we're going to do going forward. So I think it's an incredibly interesting wedge that we're seeing in the court, and I really think it's going to become more interesting even in future boring terms. Thank you.
Dahlia, and we'll turn to David Sepp.
Well, it's good to be here. I left Washington yesterday. It was 100 degrees, high humidity, stagnant air, and as people said, the political climate was worse. I think it's pretty easy to say that the big themes are free speech wins and big business wins. And at the end, if I have some time, I've got a quiz question for you as to what constitutes speech, because it seems that once something is characterized as speech, speech wins, but there's not an agreement as to what counts as speech. I wanted to talk about the case of Harry Connick versus John Thompson. Probably a case that maybe doesn't have changed the law in a big way, but it struck me as an interesting outrage of a particular sort. John Thompson, this is a story about an innocent man who was wrongly accused, wrongly convicted of a carjacking, and wrongly accused, wrongly convicted of a murder, and came within a month of being executed in the spring of 1999. And the reason he wasn't executed, I'd like to say, is because the judicial system worked, but it was really a fluke. It was just a piece of luck. The attorneys who had worked on his case for 10 years went to see him in April 1999 and basically said, "John, all of our appeals have failed, and there's nothing more we can do. Your execution has been set for May 20th, and we don't think we're going to stop at this time." Thompson's only comment was, "Do you think they could put it off for a week because my son's high school graduation is May 20th? And they said, "No, we don't think so." But they had a little money left, and there was a woman in town who was an investigator who was very well known for being able to find things. So they paid her to try to go back and see if she could find anything in the police files or whatever. And she would go to these crime labs with a low-cut blouse and a short skirt and would talk to the crime lab people, and they let her in to both the police crime lab and they let her go back into the city crime lab. And she found a microfiche of a blood test that was done a week before the carjacking trial. And it showed, this involved a young black guy tried to rob a car outside the Superdome, 3 white teenagers. There was a struggle, he fled, but bled on the pants of the young driver. And it showed that it was a type B blood. But this test had never then shown up in the carjacking case. They didn't know what blood Thompson had. They sent him a FedEx package with a letter in it and said, "John, this is urgent. take this stapled letter, take the staple, scratch your finger, bleed on this letter, send it back to us immediately. He was a type O. So on that basis, they got him off death row. They eventually won a new trial for him on the murder case, and all kinds of new evidence shown up. The most obvious one was that on the night that this hotel executive was shot on the street, 3 eyewitnesses said, one guy fled, he was a tall black guy, about 6 foot, 6'1", with close cropped hair. They had a photo of John Thompson the day he was arrested. He's 5'8" and had a big bushy afro. He looked nothing like the person who was identified by all the eyewitnesses. What happened was John Thompson was a 22-year-old sort of drug dealer in 1984. And a street thug he had known named Kevin Freeman had a gun and a ring that he sold, and Thompson in turn sold it to another guy named Funk Perkins. There was a reward offered for information. Funk Perkins came to the police and said, hey, I think I know who was involved in that case. It was John Thompson, Kevin Freeman. They arrested the 2 of them. Kevin Freeman told this elaborate story. I was out driving one night. I picked up John Thompson. We were driving down the street. He saw this guy and he says, hey, let's go after that dude. And Freeman said, no, I don't want to do that. John Thompson went over and shot him, killed him, and that's how it happened. John Thompson was brought in and says, I don't know nothing about no murder. I didn't have anything to do with no murder. And they said, come on, young man, tell us what you know. He said, I don't know nothing about no murder. So he was prosecuted, convicted, and sentenced to death based on Kevin Freeman going in court and saying John Thompson was the guy. Kevin Freeman's name was Kojak. He has close cropped hair, 6 foot tall. It was fairly clear what happened here. So after Thompson was acquitted, set free, he sued Harry Connick, the district attorney. Now you might have thought, 5 prosecutors actually known about this blood test and had hidden it. They deliberately hid it. One of them was dying of cancer and even told another prosecutor, you know, we hid some evidence about a guy. That guy kept it secret. He would have allowed John Thompson to be executed, kept it a secret. But the Supreme Court had said you can't sue a prosecutor, so he sued the district attorney. Deliberate indifference, won a $14 million award from the jury, upheld by a federal judge, upheld by the Fifth Circuit, reversed by the Supreme Court on a 5-4 vote. And Clarence Thomas's opinion is a digression about municipal liability. You know, 1983 says every person who acting under color of law violates someone's rights under the Constitution shall be liable. Harry Connick is a person, but Thomas wrote this opinion that talks about municipal liability and said we're not going to allow it for a, quote, single incident. This was described as a single incident. At the argument, Ruth Ginsburg said, well, weren't there 5 prosecutors involved in this? Anyway, they called it a single incident. Now, you could say, what's the significance of the Thompson case? In my view, it doesn't change the law in a big way. But one of the startling things about the last 15 years since DNA came to light, I think most people in the criminal justice system have been startled to find that so many innocent people have been prosecuted, convicted, and sentenced to prison, and judges have upheld the convictions, and they were innocent. And I would have thought, if you're sitting at the top of the criminal justice system, you might want to say, well, we've got to take a number of the procedural rights very seriously. One of them is the Brady Rule that says, if the police and the prosecutors have evidence that could show the defendant is innocent, they have a duty to turn that evidence over. Instead, the Supreme Court has done the worst, done the reverse in what I want to say is really the worst type of case. Because this wasn't just an accident. They deliberately withheld this evidence. And so to then throw out that award and say the district attorney is, we're not going to allow the district attorney to be sued. It seems to me the accusation here was that Harry Connick was deliberately indifferent to the rights of John Thompson. Harry Connick didn't want, presumably, an innocent man to be convicted. On the other hand, they had sort of a minimal compliance policy for Brady. They said, we'll turn over what we have to, but we're not going to turn over just everything. And he was found to be deliberately indifferent. And it seems to me that's a way to describe what the Supreme Court's decision is. They're sort of indifferent to this problem.
Thank you, David. And so now one of the panelists want to react to something your fellow panelists said, and then we'll open it up to questions. If you have a question you're watching online, you can email it to rhasen@law.uci.edu or submit it on Twitter using UCI Law SCOTUS as the hashtag.
Two quick thoughts. One is I want to disagree with a number of people who said or alluded to that this was a boring term, but next year is really going to be exciting. I think what's particularly insidious about Supreme Court decisions closing the courthouse doors is they have the same effect as taking away people's rights. They don't get the headlines or produce the outrage. If the Supreme Court had said that the government can give unlimited amounts of money to parochial schools, that made headlines. But the effect of taking away standing to challenge it is exactly the same, but people don't relate to it. The decisions about closing the courthouse doors really do affect all of us, often in a profound way. I'll go back to my example with AT&T Concepcion about arbitration. Not long ago, I went to see a new doctor for the first time, and the reception gave me a whole sheaf of papers. And one of them was that I would sign an agreement that if any claims against the doctor, I'd go to arbitration. And I said to the receptionist, if I don't sign this, will the doctor still see me? She said, I don't know, nobody's ever asked us that before. Well, I've now heard from a lot of people that doctors will not see them unless they sign arbitration agreements, waiving their ability to go to court. Around the same time, I bought a new Dell computer, and I never look on the thing you have to agree to and read the whole thing. It goes on for dozens and dozens of pages. Well, in this instance I did, and paragraph 5 said that if any claims against Dell, I agreed I'd have to go to arbitration, couldn't go to court. I wrote Dell back and said I did not agree, and by opening my envelope, they agreed I could go to court if I had any claims against them. These arbitration clauses are all over consumer agreements, employment agreements, medical agreements, and they're taking your ability to go to court. And I just say, if you think about so many of the cases that have been discussed, Arizona Christian School that John talked about, Cullen versus Penholster that Laurie talked about, Connick versus Thompson that David talked about, they're all about restricting access to the court. The second theme is, or the second thought I had is, I don't think it'd be appropriate to draw a generalization just on the basis of this term that the Roberts Court is pro-free speech. Certainly, the two cases that Dahlia talks about, Snyder versus Phelps and Brown versus Entertainment Merchants, came down on the free speech side. But if you think about the 6 years of the Roberts Court, there was Garcetti versus Sabalas, 5-4. Government employees have no claims under the First Amendment for speech on the job and the scope of their duties. Morse versus Frederick, 5-4. There's no protection for speech of students in schools if it's perceived by administrators encouraging illegal drug use. Humanitarian Law Project versus Holder last year, 6-3, divided along ideological lines that the government can punish with material assistance to foreign terrorist organizations, speech that's seen as helping those foreign terrorist organizations even in peaceful pursuits. And so I think that if you look overall at the Roberts Court, especially when it's dealing with the government and authoritarian context, it's not a free speech court at all.
Yeah, I gotta come to the defense of my former boss against Dahlia's claim that he had a somewhat incoherent opinion. It's a wonderful opinion. In fact, he's accomplished something that philosophers have been trying to accomplish for a century and a half, and that is reconcile John Locke's political theory and Rousseau's political theory. And you're not going to find that in many Supreme Court opinions. It's deep and profound, and so I encourage you to look at it.
I think someone should talk about the Arizona campaign finance case, and I think it should be Rick.
Oh. I thought my job was done. So the Supreme Court heard its 5th campaign finance case of the term since Justice Alito replaced Justice O'Connor. Fifth case since 2005. And so far, campaign finance laws are going 0 for 5. That is, the Supreme Court has struck down or limited every campaign finance law it's looked at since Justice O'Connor left the court. And Justice O'Connor is now Dahlia mentioned some extrajudicial statements. Justice O'Connor has now stated her disagreement with 2 of those cases. She said Citizens United was wrongly decided, and she said that the case decided just last month, the Arizona Free Enterprise versus Bennett case was wrongly decided. That was a case where the court struck down a part of Arizona's public financing law, which said that if you were voluntarily participating as a legislative candidate or a gubernatorial candidate in the public financing system, and you were running against an opponent who was not participating and who spent a lot of money, or there was a big independent spending campaign against you, you'd get more money. And the majority on the court found that to be unconstitutional, 5-4 decisions splitting on the typical conservative liberal lines. What was different about the case was that Justice Kagan came in and wrote the dissent, and compared to the dissent that Justice Stevens wrote in Citizens United, same 5-4 constellation except Kagan replaced Stevens, Justice Kagan showed that those on the dissenting side are not going to go down without a fight. It was a very strong opinion, and really took on Chief Justice Roberts in a way that my election law colleague Heather Gerken calls it a death match. So it really does portend that there are going to be future struggles, and there are more campaign finance cases working their way up. The big question besides disclosure, which Dahlia mentioned coming up, are questions about limitations on direct corporate contributions to candidates. I think that's a case that may get to the Supreme Court by the next year.
I pick up on that. People like me, and I think Dahlia does too, we always get emails saying you're biased because you think you don't agree with me about something. And I admit to one real bias, which is that I'm very much biased in favor of any of the justices who write well. And there aren't many. Because I'm always looking for something to quote from an opinion, and it's frequently, they can write 20 pages, and frequently there's nothing quotable. John Roberts is a very good writer. Scalia is a terrific writer in dissent. But let me read you a line, because Rick was just talking about it. Here's a line from Elena Kagan. Arizona, remember, offers to support any person running for state office. The candidates here refused that assistance. So they're making a novel argument that Arizona violated their First Amendment rights by dispersing funds to other speakers, even though they could have received the very same financial assistance. Some might call that chutzpah. And she went on for about 20 pages, really going after John Roberts, and I talked to him afterwards, and Roberts was really impressed by it. Roberts had sort of given Kagan a hard time when she was the Solicitor General, but he's been going around saying all kinds of nice things to her. She's a very sharp, very quick on the bench. I mean, Dahlia's seen this a lot. She's got that instinct, like Stevens had, of sort of waiting to the midpoint of the argument and then asking exactly the right question. So she's a real talent, and she's going to be fun to watch for a lot of years.
I was just going to pop in on a couple of things I've heard the panelists say. One is in the area of technology. We have a big case coming up next term that involves the use of GPS devices that are put onto cars. And we've thought for the last 25, 30 years, that's okay. Your car's out in the public area, the Knott's case, and the police, if they could see you by surveilling you that way, they can surveil you with technology. But now there are courts pushing back and saying that this type of technology makes life different. It's like Big Brother. They watched this guy everywhere he went for 29 days straight. And I think the Supreme Court, will have to decide how does technology play out there. The other thing is I was going to agree with David and Dahlia about interesting language. Sometimes I'm not sure what to make about it. Justice Scalia today, this term referred to tutti frutti in one of his opinions, and the standard that the court had put together. So you almost have to have the internet nearby to know what he's referring to in those decisions.
I want to pick up on the technology theme just for a moment. I agree there's going to be some rather interesting cases driven by the new technology that the court has to address. I'm not sure we're going to get a coherent read on that new technology from a court largely comprised of a bunch of 70-year-olds. And I want to give an example about this. From my time on the court, the first porn on the internet case came up. And there was a supplemental briefing ordered by the court because one of the justices had asked, how can it possibly be that computer-generated stick figures could lead to this titillating conduct that is necessary for our obscenity law? They just had no conception whatsoever about what the technology was capable of doing. And I happened to be walking by the isolated room in the library when that particular justice was reviewing a supplemental briefing on CD-ROM with shocks of, oh my God, oh my, coming out on the court. Rick began with, if you do the hash mark Twitter thing, and if you don't know what I'm talking about, they don't know what we're talking about on this stuff. And I think it was most evident in the Brown violent video game context. I don't think they have any conception about how that technology makes it different than the Divine Comedy.
I think I have to disagree with John on a very profound point. Justice Breyer testified that he did that tweeting thing.
And can I just, I'm sorry, I would just add that the best evidence, I think, of John's point was last year's pager case, where, I mean, we're talking about pagers, which actually nobody's used in 20 years. So it was amazing watching, literally the justices being, does it talk to a satellite in the sky? It was like that movie where the monkeys are, in a puddle, and you're just like, come on. But I do think that, just one side point, which was in Brown, in the violent video games case, Elena Kagan got huge props for knowing what Mortal Kombat was, but again, that's a game that I played when I was a kid, so I think it's...
That explains a lot.
Yeah, it is, there's a 20-year lag time even on the hippest justices and their technological knowledge, and it's a real problem because what they did in the pager case was agree that because they didn't know, they wouldn't make an important decision, and I think that that's a real fear going forward, that if there's some sense that we don't understand the technology, we don't make a meaningful ruling, we're in really big trouble.
There is some evidence that Chief Justice Roberts knows how to use a web browser. In the Arizona case, Arizona had claimed that its law was meant to prevent corruption, which would be potentially okay, not to promote equality. And he said, oh yeah, this is in a footnote, I went to your website before oral argument, and you mentioned leveling the playing field, and then it disappeared afterwards. So good evidence, a good tip for lawyers in the Supreme Court. You better watch out because they're looking at those things. All right, so we're going to open this up to questions. If you have a question, raise your hand. We have a mic that's going to go around. Please keep your question brief if you have a question, and please keep it as a question. We have Professor Weinstein.
This is for either David or Laurie Levenson. David, you gave a very good summary of what happened in Connick versus Thompson, but I have one question about the conclusion. You said you didn't think it changed the law a great deal, and that may be true, but it seems to have enshrined. Laurie started out by talking about a good faith exception. This case seems to enshrine bad behavior, and in fact, the case seems to stand for the principle of being a prosecutor means you never have to say you're sorry.
Well, Henry, I happen to agree, having been a prosecutor. I think what the court has said is that prosecutors and law enforcement are not as bad as they used to be. And I actually think that's their starting part. That we've come from the point where they beat the confessions on tape out of you. I guess they didn't have tape, but that, prosecutors need a certain amount of leeway, and we can't be micromanaging what they do, and that because they're not as bad, we should step out of the picture. Now, if you're a defense lawyer and your client has been within a month of being executed, you see the cup as half empty. So I think that the court gives a lot more credit to the professionalization of law enforcement and prosecutors than others would say they deserve.
I just meant, Henry, that they've for 20 or 30 years have said it's very difficult to sue a municipality. And as I say, I thought Harry Connick was a person and a district attorney, but they viewed it as we're not going to allow a suit against a municipality unless the municipality had some practice of violating people's constitutional rights. So that's what I meant. It just sort of fit in that pattern. But I think it sends a terrible message because they're not going to allow prosecutors to be sued, and they're not going to allow district attorneys who are supervising them to be sued.
Yeah, let me take the other position on this. I didn't come with kind of line item rebuttal on this particular case, but my understanding of the case, the individual prosecutors that withheld this evidence could still be sued personally. Well, they have qualified immunity.
Absolutely.
Absolute immunity. All right. So then you've got to have a pattern and practice by the city, and the question of the deliberate indifference, not taking the action when the district attorney didn't know anything about it, makes it a much closer call. It's not nearly as outrageous. Now, if the city is saying we're not going to comply with Brady, that's a policy judgment for us. The city can be held liable, and nothing in this case changes that proposition. What the majority says is you've got a single instance of a Brady violation with no evidence that the higher-ups were aware of it, taken anything to sanction it, or what have you. And if that's the case, then it really doesn't change the law at all. And all right, I knew I shouldn't have opened this.
I'm going to make it real brief. Prosecutors have absolute immunity. So I think when you look at these cases, what it means perhaps to the legal community is that they are not going to be chilled or regulated by these lawsuits. If we value a fair trial, we have to look to other methods, the ethics codes, the disciplinary procedures, but the court has sort of said suing over getting a fair trial is not the way you get to go.
We have a question over Twitter, which is going to be short, as it has to be. Predictions for next year's decision on same-sex marriage, and I should be clear that there's no case already pending at the Supreme Court. So will the court take a case? Will it be the California case eventually? What's going to happen? How would they rule if they do rule on the constitutional question?
It could be the DOMA case out of the First Circuit, which has added now a very interesting side story about the Department of Justice choosing not to defend it on appeal after it put up a feeble defense at trial. It's involved Congress weighing in to intervene and hiring Paul Clement, and then Paul Clement's firm withdrawing from the representation and Paul leaving the firm over that and going to a new firm. So lots of interesting side stories there. That's the one furthest along in the queue, where at least some of the issues will be addressed. The California one still has a huge hurdle on whether the proponents of the initiative even have standing to pursue the appeal, and if they don't have standing, there's no appeal. I don't think the court will take that case if that's the holding. An interesting side development off of that will flow if they didn't have standing to pursue the appeal, given the non-existent defense by the state at trial. Did we have a collusive suit at trial? If they didn't have standing there, that would require vacator of that decision. So that one's got a couple of procedural issues along the way that may not make it the first one up there.
Dahlia?
Is it Erwin? Did you?
The prediction, though, is when one of them gets there, it depends on where Justice Kennedy comes down. I think I'm going out on a limb on that.
When my grandmother was alive and she saw a pregnant woman, she'd always guess as to the gender of the coming baby. And if she got it right, she'd never let you hear the end of it. If she got it wrong, she'd never mention it again. I predict it's going to be a 5-4 decision in favor of marriage equality for gays and lesbians whenever it gets to the Supreme Court, assuming that these are the 9 justices. The reason I say that is based on Justice Kennedy. I agree with John, 5-4, so you have to look to Justice Kennedy. There have been 2 Supreme Court cases in American history advancing rights for gays and lesbians. Rome v. Evans in 1996 and Lawrence v. Texas in 2003. Anthony Kennedy wrote both of those. No justice on the Supreme Court has more referred to foreign law than Anthony Kennedy. Well, he's very aware that in Canada, in Mexico City, even in predominantly Catholic countries like Spain, there's a right to marriage equality. Kennedy has never been an originalist. He's always a justice who wants to be on the right side of history, and it's clear where history is going here. Just look what New York did a few years ago. And besides that, I think what Kennedy will do is much like he did in Lawrence versus Texas, or Rome v. Evans, there's no legitimate state interest in denying gays and lesbians the ability to express love and commitment through marriage, to get all of the benefits of marriage, to experience all the disappointments of marriage that heterosexuals always want to have.
I'm just going to say, sort of picking up with what John and Erwin said, I think the DOMA case is a really easy stepping stone, or it makes a lot of sense, because the claim in the DOMA cases is these are legally married couples in New England, and they've been denied equal federal benefits. So it seems to me it's very easy for the Supreme Court to say, marriage is a state matter. These people are legally married, and there is no, take the same view that Barack Obama and Eric Holder did in this case. There's no justification for providing equal federal benefits to legally married couples. So I think the likelihood is the DOMA case would get there first. They would rule on that. That's a very easy one to say, that there'd be at least a 5-4 majority, I think, on behalf of the gay rights side. And then it is a tougher question, is does Kennedy want to say the whole country must provide marriage equality? But I think they'll get there. It's just, everybody knows they'll get there. Just a question of how soon.
I was agreeing with you until that last statement.
This is Christy Dahlia. You said that there's a very different feel to the court now.
Oh,
that there are
let's just
three
wait for the microphone.
I'm sorry.
You said there was a different feel to the court now that there are 3 justices. Could you elaborate on that?
3 women justices?
Yes. And the other question is to everybody. You seem to be implying that the image that we have of the court is very different from the reality, that it's a boring court when it really isn't, and that there are very differences. And since we have media and legal people on the panel, I wonder if you could comment on how the media covers the Supreme Court.
Pretty well, I thought.
I'm going to do the first part of your question and then probably recuse myself from the second. But you know, my sense is, and it's very new to have 3 women at the court. You know, Ruth Bader Ginsburg has always said it was terrible being one, because one, she spoke for all women, and she hated that. And I think she always thought that having 2 women on the court, particularly when she and O'Connor frequently disagreed, was fantastically good, because it proved that there wasn't one monolithic chick view of the law, and I think that was really, really...
Get away with saying that.
So I think what's different is you have, you know, 3 women, arguably 3 liberal women, and yet they're so fundamentally different that I think it's really exploded the notion that women think this. And I also think, you know, one of the things that I'm finding fascinating is that when David Souter came to the court, he didn't talk at all for, you know, a year. When Sam Alito came to the court, he was very slow to jump in. I think the women on the court are in it. I mean, they're really in it. Sometimes you can't get them to stop. And for me, I just think, you know, and I always think of this just in terms of the next generation coming up. I think it's really quite thrilling to see 3 women who have, you know, strapped on their roller skates and gone. There's just no sense that they're holding back. And so I'm sort of, generally, I guess, my sense is that this has not been tentative. It's not been in any way unitary. There's just suddenly, overnight, 3 very, very different women with 3 very different demeanors at the court. And I think for that alone, it's just absolutely thrilling to see that, you know, the days when it was just O'Connor in her lacy collar speaking for all women everywhere, I don't think that helped women at all.
There are 3 New Yorkers.
I want to address the second part of your question, which is obviously I think we have the best reporters in the whole country with us right now who cover the Supreme Court. But I will say I want cameras in the courtroom. I mean, I just don't understand it. I don't think that Chief Justice Robert is going to become like Ito during an argument. And I like Judge Ito. But you know what I mean, which is all of these fears that somehow the courtroom will, you know, people will misbehave and we won't see. They are, even on, quote, the boring year, and I don't think it's boring, even every year they decide cases that are so important to so many people's lives. Wouldn't it elevate the whole level of discussion in this country about these issues to have the Supreme Court on camera? So maybe you can share with us why they don't want to move in that direction other than they're just afraid of technology.
They don't have a high regard for each other. That I've been in this discussion a lot over a lot of years, And I actually think the situation with cameras in the court is getting worse from listening to the justices. They are convinced that TV changes everything, that their colleagues would be showboating, that the lawyers would make speeches for the cameras. You know, I don't want to argue their view or defend their view, but they will tell stories about how the Senate used to be, that senators used to stand on the floor and used to engage in real debates. Now, since TV came in, they just stand up to an empty chamber, and have you ever been up in the gallery? You know, there's one fellow on the floor gesturing and talking to an empty chamber. No one is listening. And I wish it were otherwise, but my strong sense is that, also they all go through the confirmation hearings, and Dahlia and I were talking about this earlier, they all come away feeling bruised and besieged, even the ones that seem to be a fairly easy confirmation. They have a very bad view of the process. The TV is unfair, and it creates a sort of showboating. The senators are showboating. Anyways, I just don't see it happening anytime soon.
And I think one added piece to that, there's a tendency, not from David and Dahlia's articles, which I think go into the jurisprudence of the court pretty well, but the broader media, including the blogosphere, to treat the court like a box score. Well, how many times did business win? How many times did the employee win? And you can't ask that question in most of the cases that get up there. On a nuance of whether there's a preemption in Title VII for an oral complaint rather than a written complaint, that's not a question of whether the business win or the employees win. That's a very nuanced, technical reading of a statute that nobody is ever going to go look at. You know, and the propensity to box score calculating of how the court term went is going to get worse, I think they fear, as a result of putting cameras in rather than not. And that means that the notion that we're trying to faithfully apply the law, what the law says, what the nuances of the statute say, without regard to that, would more likely than not go out the window, or at least I think that contributes to their fear.
I think that's right, and I also think, you know, this question is, you know, your original question, Laurie, is why, and I think the answer is two words, and it's Jon Stewart. I mean, I really do think that there's a terrible fear of being sent up and spoofed and made to look foolish. And I'll just say briefly, the most interesting template we have for how anxious the court is about all the issues that both John and David have talked about is the audio policy. Because for a long time, the policy since Bush v. Gore was that on big cases, by some unknowable metric, that the court never disclosed, but big cases, the audio would be released, you may recall, listening to Heller or the other big cases an hour after. And you could listen to it on C-SPAN or NPR, and the question arose, why don't you just do this for all of them? If you have the technology to release the audio the minute the case is over, it would be awfully nice for America, and you know, you could still go shopping at Safeway and no one would know who you are. So it seems like the best of both worlds for justices who are, you know, very anxious about preserving their anonymity. And so for many years they had this very strange policy where they released audio for some cases and not others, and idiots like me wrote that it was a bad policy. And so this year they changed the policy, and all of the audio is released at 5 o'clock on Friday, where news goes to die. So, you know, they've really shown us what's what by making it absolutely transparent and available to the 3 people who have nothing to do at 5 o'clock on a Friday afternoon. And I do think it goes to all the issues we're hearing here, which is just they want to be anonymous. They believe that what they do is different from the other branches. They believe that there will be showboating, both on their part and the part of counsel. And so they've actually made it less accessible in terms of audio than more so. And I think that's the trend. That's exactly the trend we're going to see, is they're going to withdraw rather than let us in more.
They actually do release the transcripts the same day. So that further shows that they don't want the same. Before we end, I want to give everyone on the panel a chance to talk about the healthcare case. There are a number of healthcare cases challenging the ACA. They're working their way through the courts. I think everybody on the panel would agree that eventually at least one of these cases will get to the Supreme Court. And I'm wondering if you could reflect on one or both of these things. First, the fight over recusal, which Dahlia briefly mentioned. There have been attempts to try and get both Justice Thomas and Justice Kagan to recuse themselves in the case, and also on the merits of the case, what is the court going to do? And maybe we'll get more agreement between John and Erwin about Justice Kennedy, or maybe not.
I don't think any of the justices will recuse themselves, and of course it's up to each justice to decide for himself or herself, and that's the end of it. And I'll give you my prediction. It's going to be 8-1 to uphold the constitutionality of the health care law. I think only Justice Thomas will dissent. I think as a matter of constitutional law, this is actually an easy question. Since 1937, the Supreme Court has said that Congress can act under the Commerce Clause to regulate economic activities that, taken cumulatively, have a substantial effect on interstate commerce. So there's two questions. First, is this economic activity? And if so, second, is there a substantial effect on interstate commerce? All of us will need medical care at some point in our lives. If we have children, they have to be vaccinated in order to go to school. If we have a communicable disease, the government can require it to be treated. If we're in an accident, we'll be taken to a local emergency room. We have two economic choices, and only two. We can self-insure, or we can buy health insurance. Unfortunately, there are too many people in this country for whom they don't really have an option. They have to self-insure. But either way, it's an economic choice. So Congress is regulating economic activity. Those who say that this is regulating inactivity are just wrong, because people who aren't buying health insurance are engaged in the economic activity of self-insuring. Then the second question is, well, is there a substantial effect on interstate commerce? The health insurance industry is an $850 billion industry. Harder to think of a more substantial effect on interstate commerce. The last Commerce Clause case was the Supreme Court saying that Congress could criminally prohibit Angela Reyes from growing marijuana for own home consumption to alleviate the effects of chemotherapy. If Congress can regulate under the Commerce Clause a person growing marijuana, surely it can regulate an $850 billion industry. And just 2 weeks ago, the Sixth Circuit upheld the health care law, and a very conservative judge who had argued many of the federalism cases of the Supreme Court on the states' right side, Jeff Sutton, was in the majority saying, this is just what the precedents lead to.
John, I want to give you a chance to agree with you.
Not on this one. I can't even, yeah, it won't be 8-1. It may be 6-3 to uphold it, but I think there's a decent shot that it'll be 5-4 to strike it down. This is not medical marijuana where there was interstate trade in a commodity. There's no interstate trade in healthcare. You get it from your local physician. You kind of go a couple of steps removed to get into any, we have interstate trade in the instruments. That's not what's being regulated here. We have interstate trade in the drugs. That's not what's being regulated here. It's the healthcare provision itself, which has always been a state issue. And I think that gets you at least Justices Thomas, Scalia, and Alito, probably Roberts. And the reason I think it's either 6-3 to uphold it or 5-4 to strike it down is I think Chief Justice Roberts may vote with Kennedy. If Kennedy goes to uphold it, he may vote that way and then write the opinion himself to narrow it. But if Kennedy goes to strike it down, then I think it's 5-4. I think it's a very close case. And it's certainly closer than the pundits gave it credit to be at the outset when people treated it as frivolous. I think when you had two very comprehensive decisions by district court judges in Virginia and Florida striking it down, that caught people's attention, and I think rightly so.
I want to once again thank Brittany Rodriguez and the IT department and the communications department of UC Irvine for putting this event on, and will you please join me in thanking our speakers today.